to the latest episode of the Alternative Litigation Strategies podcast. I'm your host, Kevin Skrzowski. I'm a lawyer and a director of the litigation consulting firm Certum Group, where we provide litigation finance, claim monetization, litigation insurance, consulting, and managed services to the legal community. On this program, I host some of the greatest minds in the legal industry to discuss some of the hottest topics of today. And today we are certainly going to continue that tradition as we discuss state and federal regulatory developments in litigation finance, which is top of mind of everybody who participates in this field. And I am honored to be joined by two of the preeminent leaders in this field. I have Paul Kong. Paul is the Executive Director and President of the International Legal Finance Association, or ILFA, the leading global voice for the commercial legal finance industry, representing the funders who back major litigation and arbitration. From his seat, Paul is at the center of nearly every regulatory fight the industry is facing right now, whether it be the disclosure of bills moving through Congress, the proposed federal court rules and tax proposals, also including the debate playing out in many state houses across the country and even some international legal fields as well. He's become one of the most prominent advocates making the case for how this industry should or shouldn't be regulated. Paul, welcome to the show. It's great to have you.
Thank you. Thank you for having me.
I also am pleased to be joined by Eric Schuller. Eric is the president of the Alliance for Responsible Consumer Legal Funding, also known as ARC, the National Trade Association for the Consumer Legal Funding Industry. Eric will be quick to point out that consumer legal funding is a very different animal than commercial litigation finance. It's about getting those few $1,000s to the injured people so they can cover their rent, their car payments, their groceries, and all of their other living expenses, while their case takes its time to play out through the court system. Over the years, Eric has worked hand in hand with legislatures to shape consumer protection frameworks in states like New York, California, and Kansas. And he is one of the most active voices in the country on how this end of the industry gets regulated. Eric, it's great to have you with us as well.
Thank you for having me.
Gentlemen, let's start off by framing the conversation. To you both, I know that your associations that you lead are often mentioned in the same breath, but you represent very different businesses. Could you each please take a moment and explain how you would define the slice of the industry that each of you represent, and what's the single biggest misconception that lawmakers have when they sometimes lump you guys together?
Well, I'll start with that. The biggest issue is the opponents who don't like our space, either one of us, like to conflate the issue. And what they like to intimidate or intimate is that consumers are getting litigation financing and suing a major corporation. That Mrs. Jones is going down the street, getting several hundreds of thousands of dollars or millions of dollars, and then walking that millions of dollars down to an attorney and saying, okay, now go give me a $10 million verdict against this trucking company. That just doesn't happen. And, all our consumers are dealing with somebody who's doing this on a contingency basis. So there is no need for any kind of litigation financing in the consumer space, because consumers are not footing that bill. Their attorney may be, or in those cases, and things like that. So it's not a situation where they're doing it. And my experience is that they're purposely conflating the two issues together, is because if they can confuse legislators that, Mrs. Jones is getting money from mainland China to come in here and sue the pants off of ABC company, that hits on hot buttons that and buzzwords that they like to hear, and it just doesn't happen.
Right.
And I also agree with Eric about the misconceptions, confusing of the two, and our opponents on the other side do a really good job of that. And I think, and while I don't really understand why, I think it really comes down to they don't either know the difference or they don't care. And we're seeing that playing out. In terms of how we're different from consumer legal funding is commercial litigation finance is usually seen before federal courts. We touch on IP, antitrust, and big commercial disputes between businesses.
Yeah, yeah, exactly. And I think that there's another misconception is that it's used to fund frivolous lawsuits. And I don't think that people understand that most litigation finance is non-recourse, meaning if you don't win, no one gets paid. So, I mean, just like it's just an inherent fundamental tenet of the entire process that it's absolutely not used to fund these frivolous lawsuits.
Well, and Kevin, to your point on that, I've had discussions with legislators that they bring that up. It's funding frivolous litigation and causing companies millions of dollars, and I just politely point out to them. I said, I think the average right now is $3 to $5 million at a minimum in litigation financing. I said, let me ask you this: if you had $3 million in your pocket, would you put money into a case or into a situation that you thought was frivolous?
Of course.
And the answer is no.
Yeah.
So why would they do that as well?
Yeah, and let you see the label.
These are all of Paul's members and all of my members, we're not 501c3s.
Yeah.
We're capitalists. We're in it to make money. Why would you put money into a case or into a situation that you're not expecting to get a return on?
Yeah.
We're not nonprofits. I mean, plain and simple, we're capitalists.
Sure, of course. And Eric, you've written that consumer legal funding is not litigation finance. So I think we may have answered the question a little bit, but why does that distinction sort of matter so much when a bill land on a legislator's desk, and how often do you find that the business that you're in kind of gets swept in with the commercial funders? Is it really that common?
Yeah, it's common. I mean, we could see it in the last couple of years of all the legislation that's been introduced. The bills in Ohio, Utah, Iowa. Just give me some examples. All have it is one product. Now they slightly distinguish it between the two, but that distinction is slight. And then what we've noticed, especially in testimony from the opponents of the industry, is that they say, you talk to them offline, oh yeah, I know this is consumer and this is commercial and we need it. But when they get to testify, then they conflate the issues. They come back to Mrs. Jones getting money to bring frivolous litigation on it. And so, what I think both Paul and I are really proposing, if you want to regulate consumer legal funding, then one statute on consumer legal funding. If you want to regulate commercial litigation financing, then a separate statute on commercial litigation financing.
Sure.
This way, you're not conflating the issues and you're not, cross-pollinating, so to speak. You have two distinct separate conversations on the merits of the legislation, and you're not, putting it back and forth where it's easily confused.
Well, any additional thoughts from ILFA's side on what happens when consumer gets swept in with commercial?
Yeah, I mean, Eric's been at it a lot longer than I have, and so he's probably isn't much hair for him to pull out. But it is, and I will add this: it is legislatures in different states. It's not static, right? Every new session has new members, so it's constant education. So just because we had like a great session in another state, last year, doesn't mean we can like rest on our laurels. We have to continually educate these guys because there's always new freshman members of the legislatures that we need to educate and explain to them the differences.
That's a great point, and we are going to definitely hit on issues going on with states. But first, let's tackle the federal front, and let's discuss the Litigation Funding Transparency Act of 2026. Now, in February of this year, Senators Grassley, Tillis, Kennedy, and Cornyn introduced the Litigation Funding Transparency Act. It targets class actions, MDLs, and coordinating proceedings on a large amount of cases, which would therefore require either disclosure of funders and funding agreements. It would bar funders from controlling litigation decisions, which we don't do here at Certain Group. And it would require reporting of foreign state or foreign wealth fund involvement, which I believe has bipartisan support, and I'm not necessarily opposed to that either. But Paul, from ILFA's point of view, I know ILFA has come out against forced disclosure legislation. Can you walk us through what's the strongest version of your argument for objecting to that? I mean, is there a work product argument? Is there a competitive harm argument, or what would you say is the strongest argument?
Kevin, it's really about all of those things that you mentioned: work product privilege, competitive harm. But the reason proponents of the forced disclosure advocate for those policies has nothing to do with those that they spell out. They just want to eliminate litigation financing, disarm our industry, and eliminate the liability. And that's basically what it comes down to. And they just want to use forced disclosure as a weapon to get rid of the practice of litigation financing altogether.
Let me digress from that. What's the difference between litigation finance and law firms, especially smaller law firms and personal injury firms that take loans from banks or have lines of credit? Why not require them to disclose like every bank loan you get? I mean, where's the distinction?
Exactly, and I just feel like I think it really goes down to that. When you just kind of parse through it, there's just so many inconsistencies, and we like pointing those out. And we can get into it later with, I think, on the topic of insurance, because that's always something that we get compared to.
Sure. It does look, however, like we are going down a path where might be some type of disclosure requirement, going forward, even if like Tillis somehow gets his way in the next 6 months. I mean, is there some form of disclosure requirement that ILFA could live with? I mean, what would be livable? What would be a fallback position that you would theoretically agree to?
I don't agree it's politically inevitable. What you're seeing is the insurance industry, the guys on the other side, trying everything they possibly can to enact these protections for themselves. So far, they've been unsuccessful on the merits. So I wouldn't call it an inevitability. But to answer your question, I think we can live with the disclosure spelled out in the District of New Jersey, and our industry does live by that, and we're comfortable with that. And I think what we, as ILFA, negotiated in Kansas is a good fallback.
No, I would agree. And from the funder's perspective, if required, or if in a jurisdiction that requires disclosure, we're okay with disclosure. It's disclosure of the terms that we do not agree with, because that is actual legal work product. And the people at funders and organizations like CERTM that put those together are attorneys, and there is a work product privilege that is established. So I agree with you there. So let's so we have things going on in Congress, and we have things going on in courts, and we have things going on with Federal Rule of Civil Procedure 26. So separately from Congress, the Judicial Conference Advisory Committee on Civil Rules has a third-party litigation funding subcommittee, and they're studying the disclosure rules, and they've been doing so since 2024. Continued the study in October of 2025. They revisited it, I believe, in the spring of this year. Last March, the Lawyers for Civil Justice and the U.S. Chambers Institute for Legal Reform proposed amending FRCP A1A to require automatic disclosure of funders and their agreements. So now there's two tracks, right? So there's the legislation in Congress, and there's a possible amendment to Rule 26 to the Rules Enabling Act process. But which one of those concerns and worries the industry more, and why?
We're engaged on both fronts, and we're obviously concerned about both. But on the legislation piece, we've successfully beat back federal legislation every year. We're consistently at it. As I mentioned to you, we're educating members of Congress new to these issues, and just keeping our allies in line and making sure we're all on the same page. What is occurring with the Judicial Conference is a whole new beast, and we have less input and impact. And quite frankly, it's quite a closed process, and where we don't typically have a seat at the table there.
Understood. Okay. So now, the rulemaking process is, of course, slower and a little bit more evidence-driven than a floor vote would be. And now you have, the chamber and the LCJ are arguing that the mandatory disclosure puts funding on the same footing as insurance, which is already discoverable through FRCP 26. So is the industry better off making its case to the advisory committee, then to Congress. Multi-part question here. What's wrong with the insurance analogy? It's very important. And if the advisory committee ultimately recommends a narrow disclosure rule, like identity of the funder, but not the economic terms, would that be an acceptable landing spot?
Okay, I'll just go through one by one.
Sure.
As you know, anyone who's gone to law school knows that Congress is the ultimate authority when it comes to making powerful rules that last generations, and laws that get enacted are more durable than anything passed by the Judicial Conference. So to answer your question, a federal law enacted by federal legislation would be more harmful, but we see both as problems. Kevin, to what LCJ and the Chamber have flagged as issues that need to be addressed through Rule 26. Your colleague, Will Mara, has an article coming out in the NYU Law Review where he argues that efforts to mandate federal disclosure violate the Rules Enabling Act of 1934 and overstepped longstanding prudential limitations on the rulemaking power of the Supreme Court and its committees. It's still in draft form, so I can't and it's been a while since I read it, but it's an excellent article, and I encourage people to read it when it comes out. And Will, who has been really good on engaging with the federal judiciary, has been consistent on this issue of the insurers analogy, which is always brought up why, insurers have to make available their agreements. And one essential difference between insurance and third-party litigation funding is that liability insurance companies may control litigation, and it's accompanied by a corresponding duty of good faith owed to the insured, and third-party litigation funders owe no comparable duty. So I think that's primarily a huge, deferring analogy I would make, and there are a few others, but I would start there.
Those are all excellent points, and thank you for pointing out Will's forthcoming article, which presents a really great argument, against some of those potential laws and rules. I believe that will be a law review article in NYU, and we will certainly let the audience and the general public know, and we will broadcast that through our social media outlets, and then definitely give it to both of your organizations as soon as that is prepared. So let's talk about taxes for a second. So in 2025, everybody's favorite topic, right? Taxes. So Senator Tillis's Tackling Predatory Litigation Funding Act proposed almost a ridiculous 41% tax on funder profits, and it was inserted into the One Big Beautiful Bill. Now, the Senate parliamentarian eventually stripped it under the Byrd Rule, but Tillis publicly vowed to bring it back. So we know that this 41% tax provision was pulled out of the reconciliation bill by the parliamentarian. Tillis said, I'm quote unquote, going to go after it again. How real is the threat of a standalone bill, and how is the industry preparing, especially in light of Senator Tillis's declaration that he's not going to run again, effective January 2027, which is only about 6 months away?
I think the threat of a standalone tax legislation, I think, is a reach. And we always argue that the members of the Senate Judiciary Committee, who are much more knowledgeable about what we do, should also vet the proposal. The industry, and I can let Eric talk about the consumer side of things, is better prepared than last year, certainly. When I started my role here at ILFA, the Senate Finance and House Ways and Means were not committees I had to keep an eye on. We did not have any tax experts on our team to turn to. Now we do, so we have a better sense of what is coming down the pipeline and how to tackle it. That the Tillis tax was included in draft of the reconciliation last year shouldn't be taken as a sign of that there's broad support in the Senate. Ultimately, it was stripped out, but there is robust and bipartisan opposition to this proposal in the Senate on the merits and not just the process.
I mean, is there any legal, logical, or policy logic to a 41% tax and taxing litigation finance returns so differently and so much more than other returns? Anything?
It's still something that baffles me, and I just don't understand the logic behind it. And honestly, the discriminatory nature of the tax is probably what hurt it. And there is a point there is a point at which a tax is so punitive that the industry dies and raises no tax dollars from that purpose, from that goal that they've set out.
Yeah, and if I may interject real quick, I mean, I think to Paul's point, that's exactly what it was designed to do, was to eliminate the industry. And it wasn't to, quote, generate revenue, it was to eliminate the industry. But what I also found fascinating is when that was going on, I had some discussions with some people, and what kept coming back was talking points that was like, oh, we need to take care of this foreign money and all this foreign stuff. And I said, okay, have you got the bill in front of you? And yes, I'll say. Now hit Control F for search, type in the word foreign, and tell me where that is in the bill.
Right.
It wasn't in the bill. I said, you're not taxing foreign money. You're taxing all money.
Yeah. Everything. And I think, and I was going to ask this as a question, but it's pretty much rhetorical, and I'll just give my opinion, but I agree with you, Eric. 41% tax basically kills the industry. I mean, disclosure rules, disclosure that funding exists, I think we can live with, perhaps. Disclosure of terms, no. 41% tax kills the industry. Just kills
Well,
it.
and it was a double tax. It was taxed when the money went out, and it was taxed when the money came back in.
Absolutely. And from the consumer point, if it kills the industry, it kills individual consumers' access to justice that they wouldn't have otherwise been able to afford. And that's a very key distinction.
Right. Well, and then, they did, have a provision in there where I think anything 7% or less was exempt from it. But, example, and so some of the law firms that I talked to says, well, we're not going to be part of that. I says, well, okay. So the U.S. is never going to have an economic downturn, let's say in the next 15 years, where interest rates may go to, let's say 10%. And they're like,
Right.
Didn't think about that.
Yeah. Another light bulb moment.
Right. To Paul's point, these are, federal statutes typically don't get changed for decades, if they get changed at all.
If at all. Right. So let's talk about something I think maybe the industry agrees on, which is national security and foreign funding. So to put it into context, there's a recurring theme across the Grassley bill and state laws like Georgia that require funders to certify that they have no affiliation with foreign adversaries or sovereign wealth funds. There's a general fear that foreign states and sovereign wealth funds or adversaries are financing U.S. litigation. Now, I believe that the foreign influence concern has bipartisan traction. Paul, do you think this is a legitimate national security question, an overblown one, or a Trojan horse to just lead to a broader discussion that the industry opposes, litigation finance in general?
Kevin, there's a viral clip online from the Nevada legislature committee hearing where a U.S. chamber official under sworn testimony fumbles his way through a simple question of, can you show examples? And it's really funny. It's short, but I'm happy to share it with you. He is now the head of the international sector for the Institute for Legal Reform at the U.S. Chamber. So that apparently didn't harm his promotion within the U.S. Chamber. Mm-hmm. It definitely is a Trojan horse. They want to prove no foreign money by virtue of disclosing all financing. I mean, how else could you possibly demonstrate all financing is domestic?
I don't know. I don't think there'd be any other way.
Yeah.
Well, to that point, we just passed a statute this year in Kansas, and in the bill, we put in there that we cannot receive any money from any countries of concern, whatever the U.S. State Department has deemed. That should go without saying, but now we have it in statute. So whatever the U.S. State Department, deems, but I think where the overreaching comes is what Ohio did this year, which is just all foreign money. So are we saying that money from Canada, from France, from the UK, from Switzerland is corrupting the U.S. legal system?
You mean like allied nation versus
right, versus Syria or versus Iraq,
terrorist nations,
Iran or whatever it is, North Korea. But what's interesting is, and I've had some calls after that statute was signed by the governor of Ohio from other industries, calling me up saying, okay, explain to me why this happened and what the purpose of this is, because they're looking at this as, okay, if they're going to ban all foreign money in this industry, who's next? And then second, is this legal? Can you legally, on a state statute, prohibit a friendly company or country from investing in the United States?
That's a great question.
And Kevin, we've actually, ILFA, we've had success at the state level in places as diverse as Louisiana to Colorado, where we've convinced the legislatures that not all foreign funding is bad and that the focus should be on hostile nations, which is actually codified in federal statute, which those countries are. And I think the governors of all 50 states would attest that there is a need for foreign investments in their states, because they wouldn't be really doing their jobs if they were turning away foreign investment.
Right, and it helps the economic viability of those states that otherwise wouldn't have that opportunity. So those are really excellent points. So clearly, that issue touches on both consumer and commercial. And I like the great work that you both have done to sort of bifurcate that argument from like allied nations to like non-friendly nations. And the fact that that's codified is a very interesting point. So speaking of the states, let's talk about states a little bit then. So we all know that in 2025, there was a wave of state laws. I believe we saw Arizona, Colorado, Kansas, Georgia, Montana, Oklahoma, Tennessee, now Ohio, as you mentioned, Eric. And there's this big mix of, there's like whether you disclose it, there's funder controlled bans, there's joint and several liability issues. Georgia's 2025 Act required funder registration with the Department of Banking and Finance. On the consumer side, we saw a big law. In New York, they enacted landmark legislation. California passed AB 931. Kansas had the Transparency and Consumer Legal Funding Act of 2026. So states are very busy now. Eric, I know you've worked on consumer funding frameworks in various states like New York and California and Kansas. What does a good consumer legal funding state statute look like, and what are some of the non-negotiable consumer protections?
Well, I think that, the bill we just did in Kansas, I think is a good example, because what I found interesting in this political dynamic of across the country, it was one of only, for what we believe, is 12 pieces of legislation this year in Kansas that passed with no dissenting votes. It passed the House unanimously, it passed the Senate unanimously as a Republican legislature, and signed by a Democrat governor.
Great bipartisan support.
So, and when we had the bills come up in committee, I was the only one testifying. There was nobody in opposition to it. And it touches on a lot of things. It touches on no foreign money from countries of adversary on it. It touches on the disclosure aspect on it. So what we have in the disclosure is, if requested, you will acknowledge that, yes, there is a consumer legal funding transaction on this. Then it goes through the normal course of discovery, but in the end, it's inadmissible against the consumer. What we also have in there too is what I call a will not exceed number, meaning that each company will cap what the maximum return is on that. So the biggest thing I heard from both the insurers and from the trial bar is that, sometimes on the consumer end of things, they get to be so large, and the consumer owes, quote, so much money in it. The consumer looks at it and goes, oh, that's how much I owe. No, we're not selling. We're going for broke. We're going to trial, forcing it to go to trial. This way, if you know what that number is right from the get-go, you can plan accordingly. One of the other things that I've got some really good response from both, again, the insurers and the trial bar, is in other pieces of legislation, we've stated that the attorney cannot have a financial interest in a funding company. Well, we've expanded that to say not only the attorney can't, but their family members can't. Mm. Because what we have seen is the attorney says, well, I can't help you out. but just so you know, my son is down the hall, and he's got a company that might be able to help you out. And it's skirting that issue there, and so it's strong prohibitions on that, but then also too, it's got strong enforcement. If the company violates any of the provisions in the, as I call the thou shalt not section, not only is their contract automatically null and void, but they're subject to a $10,000 fine per incident by the Attorney General's office. So it's not a stick, it's a club.
Laws are only as good as the ability to enforce the law.
Right. So, I mean, this gets some
deterrent.
really strong deterrence in there. I mean, just like with any industry or any situation, you're going to have the bad actors out there. Just like I tell politicians, every single politician that's been elected to office has never done anything wrong or corrupted. That's never happened in the United States. I usually get a giggle out of that.
That's very good.
But, just like in our industry, you're going to have those outliers. And so what we want to do is make sure that if we're putting things in place to prevent those outliers. The legislation that we did in New York, one of the reasons that we were successful in that was we sat down with the legislators to find out what they're trying to achieve. And we found a solution to achieve that. Same thing in California. And so that's where we're getting at is we just want to find out what your goals are. Again, to our early point discussion is, when I see a piece of legislation introduced and it's got the broad term, quote, litigation financing, and I go to sit down with the legislator, what are you trying to do? Well, I'm trying to prevent these foreign money coming in, blah, blah, blah. I says, okay, what's that to do with Mrs. Jones who lives down the block in your district? That has nothing to do with it.
Yeah. That's a great approach. Find out the objective and then work in reverse to create a plan that meets the objective.
Right. What are you trying to achieve? And that's kind of what we're going with here. Our position has always been 50 statutes, 50 states. We want this industry regulated. We want to be able to have, it's different than in the commercial side of things, is because you're dealing with a consumer. And there's pretty much going to be every consumer financial product out there is going to have some sort of regulation on whatsoever. Where in Paul's case, you're dealing with sophisticated companies, sophisticated organizations. In our situation, you're going to have an attorney typically dealing with the consumer. In Paul's situation, you're going to have an army of attorneys dealing with this. You're not just having one person, second year out of law school reviewing these things. You're going to have multiple attorneys looking these things over. We can make a decision on a transaction usually within about 24 hours. Paul, correct me if I'm wrong. Sometimes it takes 6 months or more before someone makes a decision on whether or not to file the case.
Well, I wouldn't say 6 months, but Kevin could probably answer that.
Yeah. But the time frame is going to be a lot longer. And it makes sense if in our situation, you're talking $3,000 to $5,000 versus $3 to $5 million. You're going to take a little bit more due diligence in that situation than you would in something $3,000 to $5,000.
The company answers that it takes a few weeks to a few months.
Yeah.
But we move at an operational tempo that's a little faster than industry standard. So that's my 2 cents. Eric, can you talk a little bit? There's a joint and several liability provisions, and there's an argument. And I'm not sure how well versed the industry is on that. Can you talk a little bit about what that means and how you think that might harm the consumer funding industry?
Well, I mean, it's what's interesting in there is that in situations where they had a joint and several liability, they also have in the same statute that we have no say in the prosecution of the litigation. So you're holding us responsible for somebody else's actions, where we have no ability to influence those actions.
Right.
And so, it is kind of disingenuous to say, okay, you're responsible for everything here, but you can't do anything about it. It's just like saying, your neighbor down the street, committed some sort of crime. Now you're responsible for your neighbor's actions. Well, I had nothing to do with the neighbor. No, he's your neighbor. By default, you're responsible for everything he does.
Doesn't make any sense to me. I don't understand the rationale or the legality behind that at all. Yeah. Paul, on the commercial side, in Georgia, and now I believe Ohio as well, is requiring funders to register with the banking regulator of that state for any transaction that would be valued at $25,000 or more, and that those transactions would be subject to discovery. Really, I guess this is a question for both of you. I mean, we have all these states enacting this legislation. Is this whole state by state patchwork going to be workable, or is this just going to contribute to the complexity of the problem?
It's where we are, and as an industry, we're adapting. I think only one of our members has gone through the process of registering in Georgia to date. I'm not sure. I'm not sure if there will be others. I don't speak for Eric, but I'm almost accepting of the patchwork, and I just don't see how that changes anytime soon.
Yeah, as far as our members, I'm trying to keep them as uniform as possible because, most of our companies have less than 25, 30 people on board. We do have a couple that have a few hundred people, but majority of them are 25 to 30 people and staff. And when you're dealing, if you have 50 statutes and you have 50 ways your contract has to look or 50 ways of registration has to look, it makes it very cumbersome and it makes it very difficult and costly to do that. If you have to do 50 reports a year, or you have to have your contracts in 50 different organizations, or 50 ways of doing different things. So that's why we're trying to come up with a construct that keeps things as uniform as possible. Because every time you put something in there, people don't realize you're adding in regulation. For the companies to comply with that, that adds to their cost of doing business. And if you're adding to their cost of doing business, you're adding to the cost it is to the consumer.
Yeah. No, I agree with you, but in the same breath, I just don't know how you would create a uniform 50 state act. I mean, when the states have like their own rights to create their own, to promulgate their own legislation.
Well, you just try to get multiple states with the same framework, i.e., everybody passed the Kansas bill as an example.
Right. Well, I think
it's uniform. Where the problem comes in is, some states use the NMLS system. Well, that's good. Some states don't use the NMLS system. And so it's a different way of doing things. Some states, Georgia has a Department of Banking. In Ohio, it's the Attorney General's office. In Nebraska, it's the Secretary of State's office where the registration is. In Utah, it's the Department of Consumer Credit. So, I mean, it's try and keep that as uniform as possible. It just makes it easier for the companies to comply with the situation.
Yeah, I agree. And I think if people try to follow the same framework, which you've advocated and you've successfully done in working with different legislatures to get bipartisan support, that even though there's a patchwork of 50 states, hopefully there are similar underpinnings in each state regulation at the end of the day. So speaking at the end of the day, let's talk about the future and what the future looks like. If we were to look ahead, let's say 12 to 18 months, what's the one federal development you're worried about that you think will actually take effect, and the one that you think the industry can actually shape?
I'll go first. I would say the development, at least in the last year, has been the insurance industry has just thrown itself into the battle. Spending a lot of money on lobbyists and peddling inference. It's become a permanent battle. I mean, it was always a permanent battle, but it's really like well backed and has resources. But I do think that, something you touched on earlier, Kevin, developments in the Judicial Conference is something that is hard to shape, so a concern. The foreign angle piece and the other stuff, we've done a great job of pushing back on. The foreign national security stuff is unproven and just easier to dispel.
Eric, how about your views from the state level?
Yeah, I think also, I agree with Paul, I think the more immediate concern is more in the judiciary and things, but not only just on the federal side, but also on the state side. I mean, Utah passed a statute last year that requires the Utah Supreme Court to come up with discovery rules. Well, we're still waiting for that process. Pennsylvania has put that out, that they're looking at this. So not only could you have it, but those are for state courts. You know, in New Jersey, it's if I correct me if I'm wrong, Paul, that rule is on the federal side, the federal courts there.
That's
So
right.
you conceivably could have one set of rules, just to use New Jersey as an example, because there's also legislation pending in New Jersey, both on the consumer end and also on the commercial end of things. You could conceivably have one set of rules in New Jersey for a case that's in federal court, and a completely different set of rules if that same case is in the state court, in the same state.
Kevin, just
Right.
if we could just go back to that 50-state patchwork thing that we're
Yeah.
talking about. It's not legislation, and Eric just kind of hinted that it's also the courts are involved as well, right? And we take them as just as seriously as the legislatures because we have to deal with them on a daily basis. And ILFA, my organization, really likes to point out the Delaware Supreme Court. They took a serious look at it in 2023. If I'm going to point to a solution to get out of this patchwork, that would be it. I would start there. It's, it's home to a large volume of complex commercial disputes. And, the Delaware court system has every incentive to get it right, to protect the integrity of their system. And their year-long study concluded there was no evidence of systematic problems when it comes to our industry in state courts, and therefore no need for disclosure rules. So I would definitely start there. I think Pennsylvania is going to come out in the next couple of months with their own verdict on it. So I'm hoping they are also on the same side as Delaware.
Well, and then a couple of years ago, Texas did the same thing.
Yeah.
Mm-hmm.
Texas looked at the issue and came back and said, kind of like, that old saying, where's the beef? Where's the problem that we're trying to address here? And I sat in the hearing on that, and the basic consensus, well, we don't know what we don't know. Well, okay.
Yeah, and I think in terms of the patchwork internally, we're putting together a 50-state and federal regulatory and case law map, which will be published on our website and available to the public, so anybody can go and they can make sure that they know the latest for the case law, to your point, Paul, and the legislative and the regulations, so that people can stay compliant. So that tool will be coming out in the not so distant future.
Well, we'll help you market it, Kevin.
Thank you. Greatly appreciate it. I think it will help all of your members as well. So,
For sure.
Last question. If you could speak to every lawmaker across the country who's currently working in this space, and you could solve one misconception that they have about litigation finance before they vote, what would it be?
Go ahead, Paul. I'll let you go first.
Well, I have one pitch to a lawmaker.
Okay.
It's that, I just think they just need to do, I know it's hard, but they really should do their homework because there's so many misconceptions about our industry. We've covered them the last 45 minutes, we've covered some of the inconsistencies that the other side has been saying. The one thing I'd probably lead with, because it takes up a lot of the oxygen, and it's just really easy to kind of digest, not only at the federal level, but the state level, is the foreign influence thing, because that's just something that most legislators gravitate towards because it's easy to understand, and the fact that that's not really the case, and there is no, Chinese and Russian money flooding the system and clogging up the court system. I think I would start with that.
Great point.
My thing is regulate what you're trying to regulate. In other words, if you want to regulate consumer legal funding, then fine, draft legislation dealing with consumer legal funding. If you want to regulate commercial litigation financing, then draft legislation to address commercial litigation financing. Don't do things in a broad manner. Don't just say litigation financing or TPLF, I'm just doing it. You know, figure out what it is. You know, one of the analogies I use to legislators is, you know, you have commercial real estate transactions and you have home mortgages. Are they regulated the same? No, they're in two separate ends of the code. You don't regulate commercial real estate the same way you do as a home mortgage. They're two separate transactions. Regulate them as two separate transactions. And believe it or not, I think you'll find that the industry will come along with you. There's very few things when you get down and talk to regulators and legislators that both Paul and I don't disagree with them on. But you need to do it in a very responsible manner to make sure that the product is still viable and available, because both products serve a legitimate need. And if it wasn't a legitimate need, they wouldn't exist.
And I think those are excellent takeaways to conclude with. Gentlemen, those are all of the questions I had for you today. I want to greatly thank you for taking the time to provide all of this valuable information and insights to the listening audience. Thank you.
Thank you for having me.
Thank you.
And of course, I would like to thank the audience for listening. For a recording of this program, you can go to the Certum Group website at www.certumgroup.com, Apple, Stitcher, Spotify, or any of the other podcast outlets where you listen to your favorite podcasts. Thank you for listening. That's all for today. Have a great day.